Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. I'm looking at this book today, which has come to us from Law Brief Publishing. It's an important book for anybody involved in personal injury litigation. It's called Fundamental Dishonesty and QOCS, that is, Qualified One-Way Costs Shifting, in Personal Injury Proceedings. It's the law and practice, and it's been written by Jake Rowley. As I say, it's an important book. I've given the title of my review a great AIDE memoir when confronted with fundamental dishonesty defences. And I say that because this is a relatively new area. It's got some useful case law in this book, Summers in particular, and a couple of the leading authorities. And I found it invaluable now because these allegations of dishonesty are cropping up more and more, especially in the problems concerning neck and orthopaedic injuries. Let's look at the book first of all. There it is, it's a paperback. It's a very small book. There's some general blurb about the author there. There's the actual title. The back of the book has some wording. You probably can't see much of it. The internal book itself has previous works published by Law Brief Publishing right at the back. Then you've got you've got no index, but what you do have is some useful conclusions. One page of conclusions on chapter 23, basically following the line of where we are today in 2021 concerning dishonesty. So say the front of the book has that title, and then you can see the main title there. Then what we do is there's a very nice dedication for Jake's mother, which is worth reading. I always believe in showing these dedications because there's a lot of work goes into a book. We only review books which we think are worth reviewing. There's no point in reviewing a book I don't like because it's a waste of time. There's a preface which is quite useful because it explains what QOCS are for those who don't know. And it also explains the law as it now is, because it's changed quite recently in the two areas. One is section 59 and the other, of course, is dealing specifically with QOCS itself. What I then got is a contents section all the way through. And you can see it splits the book up basically into the section 57 matters, which start from chapter 14 onwards, and the earlier CPR requirements. And what you do have is some very detailed information about the various cases. The leading authorities, the ones that I certainly have been using, are well explained, they're well set out, and it sets out where the law is at the moment. And the reality of the law is very clear, which is set out right at the back of the book, and that is, it says clearly where we are today, the timing of an application under section 57, and the conclusions right at the end, looking very specifically at some of the main newer cases, although I have to say that the case law itself I think is relatively well settled. Having said that, I have a case coming up where it may well be that I'm going to be arguing in a slightly different way, but I will really be looking at the evidence of my client, who's the claimant in this case, because the defence have raised the issue of dishonesty. What do I say about the book anyway? It's a great AIDE memoir, as I indicate. I say this, that Jake Rowley's new version of the Law Brief Publishing Guide on the law and practice of fundamental dishonesty and QOCS in personal injury proceedings has been completely updated, and it's an absolute necessity if you're confronted with an allegation of fundamental dishonesty from the defence. And I say that because just reading the case law is, I found, not really quite sufficient. You need to get more of a feel for where the cases have gone and what has actually happened, but you eventually end up with the conclusion that I've ended up with, and that is, at the end of it all, it will be what the judge decides on whom he believes when an accident is caused. And it really does depend on how robust the evidence of both the claimant and the defendant are. That doesn't help you very much, I know, but it's important to realise that that's really where we are, because fundamental dishonesty goes to intent. The difficulty, of course, in the 2020s, which faces us as practitioners, is that dishonest claims and dishonest claimants, or those alleged to have behaved in such a manner, quote, are by no means a novel phenomenon in personal injury claims, nor is the insurance industry's desire to identify and expose such claims and such individuals. So therefore it's not new, it's been around a long time, and of course Parliament has expressed concern, as have the courts, about the growth in the number of whiplash cases in particular. What we have here is the author, Jake Rowley, reviews the legal framework surrounding allegations of dishonesty, the frequency with which they're made, and briefly considers the reasoning and impetus behind making them. This, of course, gives us a requirement for a new edition, which has necessarily taken on a different complexion following the introduction of the concept of fundamental dishonesty into PI litigation, which, of course, we found very helpful when faced with this type of action in preparing a case. And as I say, this sort of allegation has arisen much more frequently in recent years. As the author says, it's no exaggeration to say that for every practitioner involved in PI claims, a comprehensive understanding of the notion of fundamental dishonesty, both as it relates to QOCS, that's the qualified one-way costs shifting, and insofar as it relates to Section 57 of the Criminal Justice and Courts Act of 2015. And it's absolutely essential, of course, for an understanding of how we do things in the 2020s. And Rowley goes on, he writes, it's simply not possible to carry out practice in this area of the law without an intimate working knowledge of these principles and how they apply in real terms. That's what you get here with the book. The problem remains, though, that since fundamental dishonesty first arrived on the scene on the 1st of April 2013, as an exception to the QOCS regime, the concept had continued to develop and to expand in its reach and application. Of course, the application goes to costs, because if you have an allegation of dishonesty, the fixed fee goes out of the window, because you're now talking about a lot more money in terms of legal submissions and a quite substantial probative examination of the evidence of both parties. Now, of course, what we've got is the importance of this term obviously was adopted within the meaning of Section 57 of the Criminal Justice and Courts Act. Of course, the statute is a significant piece of legislation in itself, representing as it does a fundamental change in the law as it stood following the decision in Summers and Fairclough Holmes. Summers is an important case to read, but there are other cases, of course, as well, depending on what the facts are of your own particular instructions. The book is written from both the claimant and the defendant practitioner's point of view, bearing in mind, of course, that the book seeks to consider what is meant by fundamentally dishonest, and he breaks the subject down into fundamental and dishonest, so that you've got some idea of what those two words mean. And obviously, depending on how the judge is going with the case, you will see from the way that the evidence is actually adduced as to where the case is probably going to go one way or the other. Now, what we've got here is Rowley's purpose is to identify the relevant CPR rules that are in play and to look at the costs consequences of a finding of fundamental dishonesty. The logic of it being that you should, therefore, if you have a finding of dishonesty, that means that the defence will succeed and they will get their costs, which means a very substantial bill, of course, for the claimant and that, in reality, the insurance company. It also looks at tracing the origins of Section 57 and considers the wording and effect of the statutory provision, because it wants to obviously also look at a discussion of the principles expounded in the most relevant cases, which you have all of the relevant ones up to 2020. Now, also we have an analysis of the procedures and the processes to be adopted, not, I hasten to add, the ones I'm now facing, which are virtual trials, which makes it even more difficult in some respects because you haven't physically got the client in the room with you. But obviously it's important to know how the processes and procedures operate when making or defending allegations of fundamental dishonesty. And also what Rowley has done is he's included how and when an application for a finding can and should be made, and to provide helpful insight and commentary from a practical perspective. Let me just say finally that you don't have to plead this initially, because what's happened in the cases I've done is that the allegations are made at some later stage, so that the case then turns completely from what it originally was, which was a straightforward dispute, as on a knock-for-knock type of case, for instance, to a very much more detailed argument about the intention of the claimant, mainly as to whether that claimant basically is making a claim and acting in a dishonest manner. That really goes to the heart of the issue, and of course, if he or she loses, there's a big cost implication. If, of course, the claimant wins and the dishonesty issue is thrown out, you still got the ability, on my understanding, to seek a substantial costs award for what you've actually had to actually conduct legal research over, purely and simply because you are outside the fixed fee level. The date of publication of this paperback book is cited at the 30th of November. There's the book again. There's nothing much on the spine, and then you probably can't see anything really on there. The lighting isn't so good today. I'm getting to chapter 16 here. This is halfway through the book. This is looking at section 57 matters. The first part looks specifically at the CPR itself, but there are some extremely useful, obviously chapter 15 sets out section 57, but there are some very useful cases, and what you do is after the case has been given you get a commentary. That commentary is quite helpful depending on what the case is that you've actually got. But I'd like to thank Jake Rowley very much, and all at Law Brief Publishing, for reviewing this book and changing the title, because this has been around before, but this new book I think is important and extremely helpful for practitioners. So a very big thank you to everybody for their work on this new book. Thank you. Bye-bye.